and I am the director for our Eviction Defense Project. Thank you for joining us today for our virtual courthouse tour. Before the pandemic, we used to do these at the courthouse building and watch in the courtroom and then step outside and walk around the building, but we're hoping we can still talk a little bit about what you observed. And please put questions in the chat and I will answer them. And yes, Mary, thank you for putting that in. I will definitely address that. I actually wanted to start, I have some things, to convey a little mini program and we will keep it short, but I would love to hear questions. So I can answer the question that was just put in the chat. But also just hear any observations and maybe we can start there. So do folks have thoughts about what you just saw in the virtual courtroom, kind of how it went, things that were different maybe than what you expected, just any observations to make? I have 3 screens of lawyers. I am sure somebody has some thoughts. Thank you, Zach, for putting something in the chat. So less formal than what you've seen in other courts. And so I will say, the judges are different. And so Judge Herman, for example, I have noticed is not wearing a robe, for example, and some of the judges have, and some of them haven't during the pandemic. I will say in terms of your own dress in the courtroom, it also depends on the judge. But some judges will expect you to be wearing a suit jacket. Some judges will be fine if you are wearing more relaxed clothing. I think you probably saw that the attorneys, when they are speaking in their case, tend to turn on their video and they kind of then come to the top of the screen, as happens in a Zoom like this, and then turn off their video when their case is not being called. I see someone put in the chat also just that, there aren't waiting rooms. So this is like a real life courtroom in the sense that if there are multiple cases scheduled, everyone who's waiting for that time period is sitting in the same virtual courtroom. The court has started, yes, and I see there's a question in the chat about this. The court has started scheduling hearings in blocks. And so the great news, if you took a pro bono eviction case before the pandemic, or if you've talked to folks who have, it used to be that there might be long waits in a physical courtroom while you wait for your case to be called. And, literally the court would schedule 100 to 200 cases for a single day. And cases would be scheduled at 9, 10, 11, but everybody kind of has to show up in the morning and then they get to you when they get to you. During the pandemic, the court has realized, especially in a virtual environment, that is chaotic. To be fair, it was chaotic in person. And so hearings are now scheduled in 1-hour blocks. And so what that means is you really need to be on time because it could get called right at 10 a.m. But also if you are, for example, in the 10 a.m. block, more than likely you will be done by 11 a.m. And they tend to set a number of matters to kind of keep the number of matters each hour at a level where they can manage that. And yes, something that also came up was consent to a magistrate judge. And so magistrate judges in the landlord tenant branch handle the first few court hearings. You do have to consent to a magistrate judge as a party. That's something to talk to your client about. And I should say here, I'm going to refer sometimes to our training materials for basic housing law training. I know some of you may have attended that, some of you may not have. We will be sending a follow-up email to everyone who RSVP'd for these courthouse tours with some materials, and we will make sure to include links to our training videos. So if you didn't catch our most recent basic housing law training, we have videos recorded and PowerPoint slides that cover some of these questions more specifically about magistrate judges, but the parties do have to consent. If you came and did not consent, then what would happen is the magistrate judge would have said, okay, we will have to certify your case to an associate judge. It will have to take place on a different day. We will be in touch to reschedule that in front of a judge. And typically they can't do that the same day. That has not happened a lot. And so I don't know if they're going to get better at being able to kind of refer the same day. And they used to be able to do it when everything was in person. The main difference about magistrate judges is just if you got a decision that you were going to appeal, and of course, most decisions at an initial hearing are not going to be subject to any kind of interlocutory appeal. But for example, the case is dismissed by the magistrate judge. If the plaintiff wanted to appeal that, magistrate judge decisions are appealed to an associate judge and only then to the Court of Appeals once the associate judge considers it, and it is a shorter time frame to appeal. Someone has also asked in the chat, how long do we think hearings are going to be virtual? I don't know about the rest of you, but I've tried to mostly stop predicting what will happen next in the pandemic. But in all seriousness, what I can say is Superior Court is largely shut down still. And so the criminal division had opened up for in-person hearings. I know in recent weeks, for example, the court has continued jury trials because of the current stage of the pandemic and the Omicron variant and concerns. They've cut back on some of their in-person operations just with clerk's office being open. But in general, where we have been is all of the clerk's offices had reopened, but the only hearings that are taking place in person for the most part are in the criminal division. We expect the court may gradually reopen other pieces of the court, but we think that the landlord tenant branch is probably going to be one of the last to reopen. And so I have some PowerPoint slides that I need to switch from one computer to the next. But while I'm doing that, I know another question that was in the chat was about ERAP and Stay DC, which were referenced. And so part of what you're going to see in these cases right now is that the Emergency Rental Assistance Program and what is called Stay DC, which is a federal rental assistance program that's been in place. Many tenants will have received help under these programs. So the Emergency Rental Assistance Program is a program that has existed in the District of Columbia for over a decade, and it provides, as the name sounds, emergency rental assistance payments. Federal assistance has been available. Many of you may have seen media coverage of this, that under the appropriations bill that Congress passed at the end of last year and under the American Rescue Plan, new funds for rental assistance were made available and distributed to states and local jurisdictions, including DC. And so that is called Stay DC in the district. That program actually is out of money. DC did a great job distributing all of those funds pretty early on in the pandemic. And so when they were made available. And so at this point, about $300 million in federal assistance has been distributed to tenants. And when you pick up a case, you may see that you have a tenant who's received some of those funds. And let me just peek, because I want to make sure I've caught, and then somebody else mentioned that there are a lot of steps required before a case is filed in court. So part of what you all saw is the judge going through some new legislative requirements, and I will definitely want to mention those in terms of how you can be up to date on those. So let me come back to that. But first of all, let me go over a few more things related to changes in the pandemic world. So all court hearings and bench trials are remote. Jury trials only restarted this past summer in landlord-tenant cases, and they have been in person. They have various kind of procedures they follow for safety, pandemic safety protocols. And as I mentioned, those have actually been on hold at least for the last few weeks and are expected to be on hold, I think, through the end of this month. But everything else is remote. And I know someone mentioned, someone has jumped on here and mentioned, I missed the court hearing part. Was it recorded? So it's not recorded because we're not allowed to record the court hearings. However, if you go to the link at the top of this slide on the court's website, you can get links to go to the landlord tenant courtrooms and observe anytime you want. Similar to what many of you did today, you will just click on the link. You want to keep your video off. Please make sure to mute. I know there were a couple of times today that, folks were unmuted and that can disrupt what's going on. And you want to put observer after your name. So I would join and it would say Beth Mellon, observer in parentheses, or it doesn't have to be in parentheses, but that way the clerk knows. And I think you saw that the clerk was doing that. She was scrolling through the names and saying, okay, that's an observer, because she's looking to find the parties and see if they are there to check in. She's looking for the lawyers in each case. And so it is helpful for the clerk if you can put observer. And there are daily calendars available on the court's website. I've provided the link here and we'll send these slides to you all as well. And so if you're curious, like what hearings are happening, you can pull up the schedule and see, oh, in this courtroom, you know, there are 5 hearings at 12 noon. So maybe if I listen during my lunch hour, I can kind of see what's going on with those. And so I definitely encourage you, if you're going to take a pro bono eviction case, if this is new for you, or if remote hearings in general are new for you, please, you know, feel free to join in advance, observe, just see what's going on. And I think it'll give you a lot of familiarity with just the process and how things tend to flow. And also, frankly, a sense of the judge that you'll appear in front of. So as I mentioned, the court is scheduling hearings in 1-hour blocks. When you jump on, and I think some of you may have seen some folks doing this, you can check in orally and say, you know, this is Beth Mellon here. I'm here for case number 2021 LTB 645. I represent the defendant, my client, you know, Adam Jacobs is also on the line. You also can use the chat function, and the courtroom clerk actually uses the chat function well. I would not recommend using it with the judge, but also you may find even that like opposing counsel are not looking at the chat, but the courtroom clerk really looks at it. And so you can send a private chat just to the courtroom clerk and say, I'm here in this case. Some attorneys in my office actually put the case number after their name when they're joining the WebEx. So WebEx should prompt you for your name. And, you know, you could put there 2021 LTB 654 counsel for defendant, and then the clerk knows when he or she sees that. The other thing you want to keep in mind about these cases, and again, this may be stating the obvious, but you're not in a physical room where you can hand a piece of paper to the judge. And so if the judge is going to see something you filed, it will be because you filed it in advance and far enough in advance that it has been docketed. It is showing up on the docket, and the judge can go into the docket herself and she can click and pull up the image of what you filed. And so we recommend at least 24 to 48 hours before your court hearing, try to get everything filed. And I'm going to talk a little bit in a minute about what you need to file in advance. In our training materials, we also have tips on remote hearings and how to prepare your clients. So we would definitely recommend take a look at those. All of it is going to feel very self-explanatory and self-evident, but they're good reminders. And keep in mind that you may live in a virtual world, and you have, you know, for almost 2 years now, and be very used to how to join things online and what happens and kind of etiquette around joining things remotely, but you may be working with a client where this is completely new to them. And so things like, do you know how to mute your device? Do you know how to unmute your device? Do you want to practice doing that with me so that we make sure you know how to do it? Where are you going to be? You know, are there pets, children, other people who will be making noise in the background? How can we manage that so you have as quiet a room as possible? You know, do you have headphones that you're going to use? Let's test them and make sure they work. And so we have some tip sheets to just help you kind of walk through the things you need to think about yourself, but you're probably used to this by now, but more importantly for your client who may or may not be used to doing a lot of things in a virtual environment. I think you probably saw this with several of the tenants who are joining. A lot of tenants join by phone. They do not join on a tablet or a laptop or a smartphone with video. So it definitely can vary, but you will find that your client may say like, look, I just want to call in. And so that's something that you want to manage, bearing in mind that they will just be hearing voices. They will not be able to see that the judge is about to talk or that you are on the screen. And so you want to think about how to use the audio to talk to your client during the hearing, for example. Now, it used to be when we were in person in the courthouse, I would have told you, hey, there are legal services attorneys upstairs in these offices. Come find us if you need help. And that is not the case. But There's nowhere to just walk upstairs, but we are actually there typically in the virtual courtroom. And so when you log in, you should see somebody, and somebody was there today, that has the acronym LTLAN, usually in front of their name or possibly behind. That stands for the Landlord Tenant Legal Assistance Network. That's the name of the 6 legal service providers who have a common intake process. And the judge mentioned it at the beginning of the hearing. And so if you're in trouble at the moment, I have 2 thoughts for you. One is you can always privately chat that person. They may or may not see the chat message though. You may want to make a plan. You'll have a mentor for any case that you take. And you may want to make a plan with your mentor. If I'm in trouble next Tuesday at 10 a.m., can I give you a call? And one thing to keep in mind about these hearings is that you can always ask the judge to pass a case and say, I'm going to log off of the hearing so I can go call my client. I'm going to log off of the hearing so I can go consult with somebody. We will log back in when we're ready. And so you can disappear from the virtual courtroom and come back in, just like in the real world, you might have walked out of the courtroom, walked back in, and just let the judge know that's what you're planning to do. Mediations are also going to be remote in your case. Those happen on Zoom, and you just get an individual link sent by the part of the court that coordinates those, the Multi-Door Dispute Resolution Center. Protective order payments are the payment that a tenant has to make of their rent in a non-payment of rent case that they have to make during the pendency of the court case. Those in the past have always been made in person at the courthouse. That is still an option with the clerk's offices reopened, but payments also can be made online. We have some materials in what we will distribute to after today that include the specifics on that. And then on legislative developments, you want to keep in mind, and this goes to the pre-filing requirements. So the judge was going through with one of those unrepresented landlords a long list of things. You didn't include your registration. You didn't include your basic business license. You didn't send a past due rent notice. You didn't provide the declaration of service to the court. And so a lot of those things are in emergency and temporary legislation that has changed during the pandemic. And we are in the process of getting ready to upload documents here, but I want to show you on the Pro Bono Net DC website, there is a housing library. And if you are not already a member and you want to take cases that are eviction cases, please go ahead and sign up for the library. When you go into the library, you will see a menu that looks like this. And so if you look on the left under Housing Right to Counsel Project training materials, the last item says updated materials on new legislation. And in the next couple of weeks, we plan to put some materials in there that will help guide pro bono attorneys and frankly, our staff attorneys, because a lot has changed and it's pretty overwhelming, but we are coming up with some really great guidance documents to walk you through here what the new legal requirements are. Kind of here's a checklist, for example, to see if the landlord in your case did everything they needed to do to comply with the law. And yes, we will. I see somebody asked, will we send these slides out? We definitely will. I'm going to pause here for a second and just see if anybody has questions. You can always put them in the chat, but also feel free to hop off mute if you want to, because I am going to transition next to talking a little bit about the first few court hearings. But does anybody have questions right now? All right, I'm going to keep talking, but please put things in the chat if you have questions. So the thing I want to leave you with is just some tips on these first few court hearings. So if you pick up a landlord-tenant eviction case pro bono, those cases tend to follow a particular flow, and they're kind of quick in the beginning with a couple of hearings that come up a little quicker than in other types of civil cases, and then fall into a pattern of time for discovery and trial and so forth. So part of our goal here is to make sure you feel comfortable with just kind of how the court operates and how to handle those first few hearings. And I'm going to pause just to say, I see a question in the chat about what percentage of the cases are landlords, corporations versus individuals. It varies. We see a lot of corporate entities for the most part, but I will say right now we're having a lot of individual landlords coming into court. I think, frankly, part of that, which we observed today and just seeing a few of these hearings, is the individual landlords are not aware of all of the new legal requirements. And so they are just filing cases like they used to on a one-page form, and they think that's it. The corporate landlords tend to be represented and are very aware of all the new legal requirements, and it is taking them some time, I think, to prepare these cases and get them filed. And I should take a step back and say non-payment of rent cases in the district had been completely on hold, new case filings until October 12th. And lease violation cases were on hold until January 1st, 2022, October 12th, 2021, January 1st, 2022. And so we've only seen about 400 new cases filed so far during that time period. And there are a lot of new legal requirements, and we're seeing that even represented corporate landlords are kind of taking their time to establish a new rhythm for how to comply with all of those requirements. The other thing about corporate landlords is they've been much more aware of those rental assistance programs. And so a lot of them have been able to, apply for rental assistance, and I think not have to bring tenants to court for eviction by helping their tenants get access to those resources. I see there's a question about protective orders and bail hearings. I will talk about that in a second, but in terms, going back for just a second here, back up to the library. I think you can't see every last piece of it here, but I just do want to highlight a few things. There are sample informed pleadings here. That includes things like answers, discovery. Those also are in written materials that go with our training. And we are actually just finalizing, updating those to send around to everyone who completed our basic housing training, and we can send you all as well that information. You'll also see here something called the Getting Started Guide. And that it really walks through the same things I'm telling you today. And so we have guides that we send out with every referral, and one of them is produced by the DC Bar Pro Bono Center and is more like a treatise on DC law. But the Getting Started Guide is a practical guide. Here's what actually happens. And we are including in it now some remote hearing tips, and also information about what has changed during the pandemic, similar to what I just went over in the prior slide. And so we will make sure everyone who is RSVP'd for these courthouse tours gets them. Please be patient. That's probably going to take another week or so because we've been updating them with some of the recent changes. And then we will upload that here as well. And so part of why I encourage you sign up for Pro Bono Net is this really can be a one-stop shop for a lot of your training materials, including videos. And I should say, Adam, correct me if I'm wrong, but I think we've already gotten, we did a November 2021 basic housing law training, and I believe those videos are already up here. And so you'll see under training materials, it says basic housing law training. Those videos are there. We have a general reference binder with lots of samples that I am still working on making a few final updates. So there's a prior version there that mostly still applies. And then there are lots of other sample materials. So I really encourage you to take a look at the materials here, especially if you haven't attended a training yet, you're here today for the first time, welcome, thank you for being here. And there are a lot of materials here that can get you familiar with eviction cases, including where things are now. And you will see in our basic housing law training series we did in November, we had 4 sessions. The last session was all about new requirements in DC law. And so if you've handled a case before and you're here today because you want to take a case, this year at some point, but you realize there have been some changes, we have a training, a particular training we did on new legal requirements that is directed specifically at you. But the 4-part training series goes over everything I'm talking about in much greater detail. So let me go back. So the first hearing in an eviction case is called the initial hearing. If it gets continued, the court will refer to it as a further initial hearing. And so I just want to go over the basics of what happens at these hearings. And this is what you were seeing in the cases where, for example, the gentleman said, you know, I went to the courthouse today because I didn't know I was supposed to appear remotely. It was his initial hearing date in that case. And the case that was called before that with two unrepresented parties, an unrepresented landlord, unrepresented defendant, where the case got dismissed, that was their initial hearing. So if you pick up one of these cases, our goal is to get it to you before the initial hearing. And you want to, be prepared for that initial hearing when you walk into the courtroom. And so part of that, of course, is talking to your client. In the Getting Started guide, we have some sample interview questions for a first interview with your client to gather all those facts you need. So you really want to, find out what's going on, gather as many facts and documents from your client as possible. And what you're going to want to do in terms of documents. And so if I can flip between what needs to be covered in the hearing and preparing with your client, if you need more time, you can ask for a 2-week continuance is what is standard and in the landlord tenant branch rules. You do have to ask for that quote unquote, all rights reserved to make sure you reserve your client's right to request a jury trial. And that is something that you and opposing counsel can agree to and submit something in advance to the court. We have a sample of what to submit in our Getting Started guide. Or you can ask the judge for a continuance and say, I'm a pro bono attorney. I got this case assigned last week. My client and I have only been able to meet once. We need a little more time to prepare, for example. But what you're going to do at that initial hearing in general, you're going to file your initial pleadings. So one is an application to proceed in form of papyrus or Ifp application. Again, we have this in the Getting Started guide in terms of the actual court form. This is to ask the court not to charge your client any fees in the case. This can be submitted in advance on paper, and you can actually submit this as soon as you meet your client, do it before you even file the answer. Because in general, they are ruled on by the court on paper. You don't have to be at a hearing. Hopefully it will be granted. There will be an order on the docket and you will know that's taken care of before you even come to that initial hearing. And then you need to file a responsive pleading. So that's an answer. And if you're requesting a jury trial, that jury demand is going to go in that answer. So going back to thinking about preparing with your client for this initial hearing, you need to know what's going on so you can understand what defenses do we have, what claims are we going to make, because I need to put all of that in the answer I'm going to file with the court. And then, going back to the Ifp application, of course, you need to know the information that's requested in that application that relates to income or public benefits. Most of the cases we refer under this project, our clients get public benefits where they don't have to disclose all of their income information. They can just say to the court, for example, I get Medicaid, I get food stamps, and therefore I should not have to pay fees. And so you want to make sure that you understand what's going on enough to be able to file your answer and set out your defenses. For example, in a non-payment of rent case, do they dispute how much is owed? Do they say that rental assistance was approved, but their landlord hasn't credited it? Sounds like that was an issue for one of the tenants this morning. Do they have housing code violations and they say the rent should be reduced as a result of that? And those are the things you're going to set forth in your answer. And our training materials and samples go over all of that, but you're going to want that to be prepared. Ideally, you're going to want to file that in advance, as I mentioned, so that the judge can pull it up and see it. And I should say filing right now is completely electronic. There is no in-person paper filing. So you will need to be registered for what's called Case File Express. Most firms in the federal government have accounts. And so you just will have to find out how to make sure that you're registered if that's not something you're familiar with so that you can submit filings. And so hopefully you would file that answer in advance of the hearing so the judge can take a look at it. And then for non-payment of rent cases, so this is where we get to the protective order. A protective order is just an order for the tenant to pay the rent that they currently owe to the court. So it's in a secure place. And is kept, separate by the court to be resolved as part of the trial in the matter while the case is pending. So a protective order cannot go back earlier than the initial hearing date. You know, if you are in court on January 7th and that is your first hearing date, that is the date the protective order can start. It is not about the back rent. It is not about having to provide some kind of pre-judgment security for that. But it is pre-judgment security for rent that is due while the case is proceeding in court. It can be set just at the full rent amount. If the parties agree what that amount is and your client can pay it, you can do that. But there may be reasons, either practical reasons or legal reasons, that you want a reduction. And that is what a Bell hearing is. It is a hearing, it's named a Bell hearing after a case, Centolis Realty versus Bell, that established this concept of a protective order, but also established the concept that a tenant can ask for those payments to be reduced based on, for example, housing code violations currently at the property. And just keep in mind, there are other reasons you can ask for a reduction. And so let's say you have a tenant in subsidized housing, their rent is income-based, and they say, well, my rent's miscalculated right now, and I told them I lost income and they didn't reduce it. That could be a reason that you want a lower rent amount. You could have a landlord in the private market who just says, you know, I increased the rent by $200 a month last year. And you say, well, my client says they didn't get notice. Notice is required. And so that was an illegal rent increase. And so there can be lots of issues that come up. Housing code violations is one of the most common. So at that initial hearing, you're going to do one of two things. You either will agree the protective order will be this amount and here's what the payment schedule will be, or you will say to the judge, we need a Bell hearing because my client wants to reduce the amount owed. Strategically, if you want a little more time for your client to get money together to make that payment, if you want a little more time to talk to opposing counsel about repairs related to this, you may decide to set a Bell hearing, even if ultimately you're just going to reach an agreement with the other side about what that rent amount is. And certainly a protective order is a place where you should negotiate with that opposing party and their counsel. You know, you can skip the first payment. You can have payments due in the middle of the month. You can reduce the amount owed. You can have a lower amount for the first few payments and then full rent. So anything the parties can agree on, the court will enter as a protective order. And so you definitely want to talk to opposing counsel or the opposing party about this. And I'll say a little bit about that in a minute on the next slide. I'll come back to that. But going back to the initial hearing, you're going to either set that protective order or schedule that Bell hearing. And then you're also going to have a discovery schedule and mediation. And then if possible, you want to go ahead and serve your discovery. And that is because these cases are on a little bit tighter schedule than most civil cases. And so being able right up front in the case to serve your discovery is ideal. If you, to talk about jury trials and discovery first, if you look at my note here on jury trials, typically the schedule is going to be a close of discovery in 45 days. So essentially about 6 weeks from today's date. That's not really enough time. Discovery responses are due 30 days unless the parties agree to something different or the court orders something different. And so even if you serve discovery at that first court hearing, you know, you have 30 days until it's due, and that only leaves you 15 days if they don't respond, if they give you responses that are incomplete, if you need to file some kind of motion to compel. So I generally recommend at least 60 to 75 days. That's something you can ask the judge for. So, you know, today's January 7th, I would probably be saying to the judge, Your Honor, can we close discovery in mid-March? And that will give us plenty of time to serve requests, deal with any deficiencies that come up. If we need to file a motion, and hopefully have all of that set in place before we go to mediation. The other date that will be set in a jury trial or bench trial case is a mediation date that happens through a separate part of the court called multi-door dispute resolution center. And when I have discovery in a case, I really want that discovery done before mediation, because mediation is just going to be so much more productive if I have a sense of where the case is going, what the other party's claiming, what kind of evidence they have. And so the idea is I would want my mediation after that close of discovery. For bench trials, going back to them for a minute, which is a trial with a judge, they are on a different schedule. It's more expedited. The court at this point as a practice is scheduling mediations in all of those cases. Discovery in those cases is not provided to the parties as a matter of right. You have to ask for it. And so if you are requesting a bench trial in your case, not a jury trial, you'll want to talk to the opposing party or counsel and try to agree on this if possible. And if not, orally present a motion to the judge at this initial hearing to say, Your Honor, we'd like some discovery. You know, we're asking for a bench trial, not a jury trial, but we do want discovery in this case. So we're making an oral motion for discovery. We're asking for this many interrogatories, this many requests for production. Here's the schedule we'd like on discovery. And go ahead and see if the judge can set all of that as part of setting these dates. And I should say in landlord-tenant cases for jury trials, the parties are entitled to 10 interrogatories, 10 requests for production. And so it is more limited discovery, and generally in bench trials, we would ask for that or potentially even less. And sample discovery requests are part of what we have on Pro Bono Net, and also your mentor can provide you samples, including suggesting, you know, here's something for a non-payment of rent case with these particular issues or facts that you might want to consider. And so keep the questions coming in the chat, or please unmute if you have a question. But I do want to touch on protective orders as well. So as you might imagine, that protective order, it's a court order. If your client misses those payments, there are sanctions that can happen. And that could include things like losing your jury trial and having to have a bench trial, losing your counterclaim if you have filed one, losing your defenses, which is the most serious because that means that you, are not really able to contest the case against you. And so because there are sanctions for missing these payments, you want to, before you agree to something on that protective order, before you formulate what you're going to ask for, if you need a reduction, if so, how much, you want to have a really frank, open conversation with your client about their finances and their rent, how they're going to pay it, when they can pay it, especially if you have a tenant who has not paid rent in a long time. In the pandemic, this may be accentuated, or has had income changes because of the pandemic. You want to have a really honest conversation with them about that. And, be gentle, be kind, be patient, but be as direct as possible. And so you really want to set aside time to do that, because this obviously is something that requires some care and building some trust with your client, but is really important to have happen. The court, maybe a little more than usual during the pandemic, has been somewhat understanding of tenants having a different economic situation. And so you'll want to talk to your client about this and the strategy around it, reach out to your mentor, but you may decide you want to be really candid with the judge and just say, like, look, my client used to work 40 hours a week and now is only getting 20 hours a week. They really can only afford to pay half the rent, but we're asking you to let them pay that amount, keep this case going so they can ultimately defend it on the merits, because we think we have claims and defenses to have litigated here. So keep that in mind. When you're talking to your client, about this issue, about the protective order, you want to make sure they understand it's important to be honest with me about what you can do and be honest with yourself, because if you commit to make these payments and you miss payments, here's what could happen in your case, and it could speed up your eviction. So you really want to make sure they understand the importance of this conversation. I mentioned that the protective order, there may be some legal issues that come up, for example, related to calculation of an income-based rent. But other examples, maybe the tenant subsidy was terminated and you think that's improper and you want to argue, they should get their subsidy back. Maybe the subsidy payments were cut off because the landlord violated the program rules, and you want to say, hey, the landlord can't charge this person full rent because the only reason the subsidy got cut off is because the landlord didn't make repairs or the landlord violated this rule. And those are things where we have sample briefing, but you just want to flag those issues early on to think about, okay, do I want to submit some legal briefing to the judge in advance to say, here are the program rules, here are some documents that show the landlord is at fault. And when you schedule that bail hearing, you want to make sure you have time to do that. So for example, you might say to the judge, Your Honor, if we could push this out even 3 or 4 weeks so that we have time to submit a brief to the court in advance, we think there are some legal issues in the court and both parties will benefit if we're able to lay that out in briefing before we have this hearing. In terms of what to expect for these hearings, they can be everything from a proffer to a full-on presentation of evidence and presenting argument. And so you want to be ready for all of that. What is more typical is just a proffer of evidence. And for those of you who may not be litigators, that simply means saying to the judge, Your Honor, if my client were to testify today, she would testify that she has housing code violations, that she's notified the landlord. If I may, here are the 5 most serious conditions. I have photographs I can pass up that show these conditions in her home, that kind of thing. But a judge in a contested, matter may say, well, I need to hear some evidence. So put on your client as a witness. And you want to think about what that looks like in a virtual world. Our remote hearing tip sheet and the slides in our recent training about that, talk about that a little bit. But you're going to want to think about, am I going to be in the same room with my client while we're doing this hearing in case, he or she has to testify? Am I going to, we'll be in different rooms, but I'm going to give them a paper copy of all the exhibits in advance so they can follow along. How are you going to do a direct examination if you and your client are not in a courtroom before the judge? And generally with the Bell hearings, the judge will set a deadline to submit exhibits for that reason, because they need to have them in advance in front of them, if at all possible. And so preparing, you want to be ready to do direct and cross examinations of witnesses. You also want to have your documentary evidence. And so photographs of conditions, if that's relevant, inspection reports, paperwork related to a housing subsidy, anything that you're going to need to rely on. And keep in mind, you need to have a witness who can get that document into evidence. Who can authenticate that document where necessary. We have tips on how to do that with government agency documents. You don't always need to have a witness there, especially if the opposing party or a counsel agree. But those are issues you want to think about and prepare for. And then the ultimate outcome at the end of this hearing is going to be that protective order issued. The court issues something called a protective order information sheet. That is something else that we have a sample of in the Getting Started guide. And it just tells your client, here's what you have to pay, here's when the payments are due, here's how to make the payments. So that is what would come out eventually at the end of the hearing. The court, I believe, has not issued this yet. I will have to double check because they were talking about it at the end of last year. But they were in the process of updating that protective order information sheet to reflect some pandemic changes. And let me peek. Okay, so a Bell hearing is the hearing where the court would determine what that protective order is going to be. And so that would be a hearing where the tenant would be presenting evidence to support any request for reduction in that protective order. So for example, if the tenant is saying, I have housing code violations, I shouldn't have to pay the full rent until repairs are made, the tenant would have to come prepared to show the court and prove that there are in fact current housing code violations. They were reported to the landlord did not make repairs. If there's another reason, another basis to request a reduction, the tenant would have to be prepared to present that evidence. And you as a lawyer, if there are legal arguments involved, would have to be prepared to make those legal arguments as well. Do folks have other questions? I will say this is the end of my slides, and I'm happy to answer any questions you may have. The goal is just to give you a little taste of what it's like to handle these first few court proceedings. And so I hope we've been able to do that through watching a couple of these hearings and then giving you a little bit more information. And as I mentioned at the beginning, I really encourage you, if you're going to take on a case in the future, take a look at some of our training materials, take a look at the Getting Started guide, and we will be emailing follow-up materials to you all. Take a look at those, including, you can review these slides again, and also just go observe some court hearings. Bell hearings do not happen that often, but I will just note here that Courtroom B109 is where initial hearings, status hearings, and so forth happen. Courtroom B53 is the courtroom where motion hearings and Bell hearings and bench trials tend to take place. And if we go back for a minute, and then I'll answer the questions that have come up in the chat. So if you go to this link right here on the court's website for the remote hearings, and actually, I think if I will let me click on it while I'm in the middle of this, yes, it will. And so if you look, you can go down, so it has the civil courtrooms listed right here. And then if you just page down, you will see down here B53 and B109, and those are in WebEx. And I'm gonna stop sharing for a second. And so in the chat, someone asked about pre-marking exhibits. Adobe, advanced version of Adobe, Acrobat allows you to pre-mark exhibits electronically. There are also other programs that are available online for free that will allow you to edit PDFs. And so I know we have sometimes used those to pre-mark exhibits. It is a good idea to pre-mark your exhibits. And just think about that if your client is going to be sitting at home on the phone, you're going to be, at home conducting a direct examination, you want them pre-marked for your client as well, so that you can say, Miss Mellon, I'm going to ask you to turn in the binder I gave you to Exhibit 1. Do you see Exhibit 1? Your Honor, do you have Exhibit 1? And Your Honor, I've previously provided electronically to opposing counsel and filed with this court these exhibits. And so all of this right now is happening virtually, as opposed to when you're in a physical courtroom and you would be saying, Your Honor, I've handed to opposing counsel my exhibit. May I approach to provide it to Your Honor? And then there was a question about, do landlords typically request protective orders at initial hearings? They do. And actually, if you look on the form complaint, there is a box at the bottom for the landlord to request a protective order, and they typically check it off. The landlord tenant court rules say, even if it's requested in the complaint, it cannot go into effect until that first court date. That's the first date it could be entered, and that it is only prospective. I will just say one other thing you probably want to do before you go into the first hearing in this case is look at the landlord tenant branch rules. So there are rules, we reference them in our training as applicable, but they're not that long. The whole set of rules is 20-25 pages. So you might want to take a glance at those and get some familiarity. There is a specific rule just about protective orders that goes over these things, and it's good to have that handy in case questions come up. Someone asked in the chat, is the landlord responsible for filing for rental assistance on behalf of a tenant as a prerequisite for filing? They were required to do that until January 1st. And I will say Judge Herman is new to the landlord tenant branch just this week. I think she's doing fabulous for being brand new to the landlord tenant branch. But when she was talking to that pro se landlord and saying, you just have to refile, you have to do this, that, and the other. And she said, you have to apply for stay DC. As of January 1st, that is actually incorrect. And so the district passed legislation with all of these prerequisites to filing as a way of kind of unwinding the moratorium that had existed on the filing of new cases. And so the council said, you can file for non-payment of rent starting on October 12th, but if you're going to file before January 1st, 2022, first you have to apply for stay DC, this rental assistance program, on behalf of your tenant. And you have to wait 60 days for them to complete their part of the application and get it approved or denied. And if the tenant responds in that 60-day window and they complete their part of the application, you have to wait for a decision on it and wait to get that payment before you can sue. And that is another reason we think that we have seen not that many filings, including, as I mentioned before, from corporate landlords who know about all these rules and are following them, because the District of Columbia is still working through all of those rental assistance applications. The Stay DC program closed for new applications as of October 27th, but the district government is continuing to work through all of the kind of final applications to grant or deny them, to issue checks and so forth. And so we are continuing to see that be an issue that's kind of lingering in these cases. Does anybody else have any questions? I will also make sure that Adam Jacobs puts my email in what we send out. And so Adam Jacobs reached out to you for today's courthouse tour. If you have any immediate questions, feel free to check with him, but you can expect to see a follow-up email from Adam. As I said, please just be patient and give us a week or two because we're trying to get all of our materials fully updated so we send you the most accurate, up-to-date information as possible. And we then will be also putting our updated materials up on Pro Bono Net. You'll be able to find them there. So thank you so much, everyone. We really appreciate your interest in taking on a pro bono eviction case. I should have said at the beginning, I've been practicing eviction defense law, believe it or not, for over 16 years in DC. These are amazing cases to take on. You can have a huge impact for a family in need and really help someone navigate a court process and get to a result that keeps them stably housed. And, you know, work with a terrific client and their family to make a real difference in their lives. So we definitely encourage you to take on cases. I will say, as I alluded to, we haven't seen that many cases filed yet. And so we're trying to get folks ready to go and provide training and observation and tell you how to get ready. And we will be, you know, talking to firms about sending out cases as we see more cases filed. A lot of the protections ended. Those pre-filing requisites ended or changed on January 1st. So I am expecting we will see gradually an uptick in filings and we'll have some cases available to send to you all. So thank you, everyone. And definitely reach out if you have follow-up questions. Look for our follow-up email. Take care.